Let's take a look at a key case within the law of tort. This is the case of Cambridge Water Company and Eastern Counties Leather. This is a case that concerns the tort of Rylands v Fletcher. Let's take a look at the facts of this case. The defendants in this case were a business known as Eastern Counties Leather, and they were manufacturers of fine leather. The claimants were the Cambridge Water Company. The facts of the case were as follows. The defendant in their manufacturing of leather used a chemical called PCE, and this was used on their premises as part of their processes. They had not realised that the chemical was seeping through the floor, through the ground, and contaminating water, which then fed through to a mill which was run by the Cambridge Water Company. Trace elements of the chemical were found in the water was contaminated, and the water company then sought an action against Eastern Counties Leather. They originally sought the action upon the basis of negligence, nuisance, and Rylands v Fletcher. The claims in negligence and nuisance failed upon the basis that the type of harm that was caused could not have been reasonably foreseen. Originally, the claim in Rylands v Fletcher also failed, but there was an appeal, and at this appeal they sought to consider whether or not it was required that the type of harm be reasonably foreseeable also within the tort of Rylands and Fletcher. The outcome of this case was that they were also not liable under the principles of Rylands v Fletcher, and that is because, similar to nuisance, the tort of Rylands v Fletcher requires that knowledge or at least reasonable foreseeability of the possible damage, if there were to be an escape, must be foreseeable. Foreseeability of the type of damage suffered is a prerequisite of a claim in Rylands v Fletcher. Foreseeability of harm of the relevant type must be proved, and that could not be proved in this case, as it was held that nobody could have foreseen the damage that occurred and the way in which it did so. Contamination of water 1.3 miles away via this method could not have been foreseen, and therefore the claim failed.